Good morning. I'm Gary DeWaal, and this is Bridging the Week for June 13th to 17th, and today is June 20th, 2016. Last week, the Securities and Exchange Commission overturned the decision of the Chicago Board Options Exchange in a disciplinary matter that had fined a broker-dealer and two principals $1 million for not applying customer identification and margin requirements to traders of two Omnibus accounts. The SEC said the CBOE misunderstood who were the broker-dealer's customers. Separately, a trader was sanctioned over $3 million by the New York Mercantile Exchange for trading on his employer's confidential information to the detriment of his employer. While the Commodity Futures Trading Commission submitted papers in an enforcement action in a Chicago federal court arguing that the definition of spoofing is clear. We have some very interesting articles this week, so let's get started. The Securities and Exchange Commission set aside a determination by the Chicago Board Options Exchange that electronic transaction clearing and two of its principals, Kevin Murphy and Harvey Cloyd, failed to apply its customer identification program to individuals trading on behalf of two Omnibus accounts, failed to apply margin rules to the same traders, and failed to implement adequate surveillance tools for identifying suspicious activities of its customers. Previously in 2011, CBOE filed charges against the firm and the two principals, claiming that between December 2009 and July 2010, the firm failed to comply with the SIP rule and margin requirements in connection with the multiple individual traders. In case you forgot, the SIP rule references a requirement under law and of the Financial Crimes Enforcement Network of the U.S. Department of Treasury that broker-dealers as well as certain other financial institutions must obtain, verify, and record certain information that identifies each person who opens an account. The CBOE BCC also found that the firm failed to have adequate surveillance tools in 2010 because for a portion of the year, it temporarily deactivated its electronic monitoring system for potential wash sales and other possible manipulative activity. The BCC also found other violations and imposed a $1 million fine against ETC and the two principals, as well as other sanctions. The firm and the two principals appealed the BCC's decision to CBOE's Board of Directors. The board upheld the BCC's decision. The applicants then appealed to the SEC. In ruling against CBOE, the SEC said the SIP rule only required ETS, quote, to verify the identity of the name account holder, end of quote. Because ETS's named customers were the two Omnibus brokers, it was only required to apply its SIP requirements to them. For this reason, too, only the Omnibus brokers, not their traders, were subject to CBOE's margin rules, said the SEC. Finally, the SEC noted that ETS temporarily deactivated its surveillance system for bona fide reasons, to make the monitoring tool web-based as it was requiring, quote, extensive computer resources to run, end of quote, and not operating efficiently. A panel of the Business Conduct Committee of the New York Mercantile Exchange found that from April 18, 2012 through December 10, 2012, John Ruggles, a non-member and former trader for Delta Airlines, traded two accounts of his wife, Yvonne Ruggles, relying on confidential information of his employer in a manner that disadvantaged it. According to the BCC, on 82 instances during this time period, Mr. Ruggles either initiated as a new position opposite his employer's account, offset a position opposite his employer's account, or front-ran orders ultimately placed for his employer's account. The BCC concluded that, during the relevant period, Mr. Ruggles accumulated profits in excess of $3.3 million as a result of his unauthorized trading. As a penalty, the BCC imposed a fine of $500,000 against Mr. Ruggles, ordered disgorgement of an excess of $2.8 million, and imposed a permanent CME Group all products trading prohibition. The BCC did not order disgorgement of the entire amount of his alleged illicit profits because it noted that CME Group exchanges did not have the requisite authority to impose such action against a non-member until August 20th, 2012. The Commodity Futures Trading Commission filed papers in its lawsuit against a proprietary trading firm and its principal, claiming that the federal law prohibition against spoofing is not unconstitutionally vague. Previously, the defendants in that action made a motion to the federal court in Chicago hearing the CFTC's lawsuit that charges against them should be dismissed because, among other reasons, the definition of spoofing under law does not provide adequate notice regarding the prohibited conduct. The CFTC in response claimed that, quote, the spoofing provision of the relevant law is clear and defendants' conduct falls clearly within that language, end of quote. Previously, the defendants argued in support of their motion to dismiss that the CFTC has never provided official notice of what activity might qualify as spoofing or be of, quote, the character of or commonly known to the trade as spoofing, end of quote. Defendants argued that, quote, the CFTC has had 5 years to try to rectify the vagueness of the spoofing statute by issuing a rule or regulation to prohibit trading practices that may constitute spoofing, but it has failed to do so, end of quote. And finally, the U.S. Department of Justice and the Securities and Exchange Commission filed criminal and civil charges respectively against a former government official who obtained confidential information from his former agency and then provided it to a hedge fund manager for trading. According to the SEC, Sanjay Valvani, a hedge fund manager, realized a $32 million US illicit profits after receiving information about the likely approval by the Federal Drug Administration of a new generic drug. He received this information, charged the SEC, in a civil complaint filed in a federal court in New York from Gordon Johnston, a former senior FDA officer whom he had hired as a consultant. Mr. Johnston obtained this information through a former colleague at the FDA. In response, the SEC alleged that Mr. Valvani also shared this information with another former hedge fund manager, Stephen Lumiere, who likewise traded on the insider information. All the individuals were sued by the SEC for this matter, and these actions are pending. Criminal charges were also brought against each person. Mr. Johnston pled guilty and admitted to his conduct. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal, and until next week, have a great week, and ciao.